I would obviously ask him to acknowledge his awareness of that for the record, and I think it's fair to say, and I've discussed it with counsel, I anticipate going forward, somewhat unrelated to this first appearance, that there will be additional charges that we will have to entertain related to the additional injuries that were sustained by non-fatal injuries, essentially. So I anticipate that those are forthcoming, but for the purposes of today's hearing, just the two-count complaint, both counts of death by auto.
All right, thank you, Mr. Troiano.
Thank you, Judge.
Counselor, have you received a copy of the complaint?
Judge, I have, and I can represent to the court that the defendant has as well. I want to place on the record, Judge, if you'll permit me, my appreciation to Mr. Troiano and his office for his cooperation with my office in turning in Mr. Mudrow. We appreciate that very much.
All right, that's noted for the record, counsel. Mr. Mudrow, have you had an opportunity to read the complaint that's been filed against you, or at least discuss it with your attorney? I'm sorry, Mr. Mudrow?
No, sir.
Do you have were you given a copy of the complaint at the time of your arrest? All right. You'll have an ample opportunity to discuss the complaint with your counsel as the case moves forward. In addition, you'll be provided, if counsel hasn't been provided already, discovery in the case. By discovery, we talk about police reports, witness statements. Any investigation that's conducted will be disclosed to you and your attorney for discussion as the case moves forward. Do you understand, Mr. Mudrow, that you are currently charged with two second-degree offenses called vehicular homicide? It's also referred to as death by auto. Do you understand those charges?
Yes.
All right. As second-degree offenses, the penalties you face include a potential term of imprisonment on each of those second-degree offenses of between 5 years to 10 years in New Jersey State Prison if you are convicted of those offenses. Is that clear?
Yes.
Right. Because of the nature of the offenses, they are also subject, as the prosecutor referenced, to the No Early Release Act, referred to commonly by its acronym of NERA, N-E-R-A. And what that requires, if you are convicted of these offenses, the statute requires that the court impose a period of parole ineligibility of 85% on whatever sentence the court might impose on you if you are convicted of the offenses. Is that clear?
Yes.
You do have the right to remain silent, Mr. Mudrow, and anything you say in court can be used against you in a court of law moving forward. You certainly have a right to be represented by an attorney, and you have very competent counsel that you have retained to represent you on this case. With regard to future hearings, you have a right to a hearing as to probable cause for the underlying complaint. You have a right to indictment by a Morris County grand jury. Grand jury acts as a buffer of sorts between a criminal defendant and the state. The state is obligated, when a case is presented to a grand jury, to provide some evidence on each element of the offenses and the complaints against you. You also have a right to a trial by jury because of the nature of the offenses. At any trial, the burden is always on the state of New Jersey. There's no burden on the defendant to prove your innocence. You're presumed innocent up until a jury says otherwise. You also have the right to waive indictment and waive a trial by jury and have the case tried before the court, the judge sitting without a jury. Do you understand those rights?
Yes.
All right. And Mr. Mudrow, in looking at the paperwork, I see that you are a citizen of the United States. Is that correct?
Yes.
You were born in South Carolina. Is that correct?
Yes.
All right. The reason why I asked that question is just to confirm that there are no potential immigration consequences if you are convicted of either of these offenses or any other offenses. Are you a military veteran at all, Mr. Mudrow? There's a program I need to advise you of. It's called the Pretrial Intervention Program. It's commonly referred to as the PTI program. This is essentially a state-run program. It's a diversionary program. And although you are charged with serious offenses, second-degree offenses, you may still be eligible for the Pretrial Intervention Program. There's an application that would have to be filed. The Criminal Division Manager's Office, if you file such an application, would make an assessment of your eligibility for the Pretrial Intervention Program. and then the determination is up to the prosecutor's office whether or not to allow you to enter into that diversionary program. Do you understand the pretrial intervention program, Mr. Muldrow? If not, counsel will explain it to you in more detail. And if the prosecutor rejects you from the program, you do have the right to file an appeal before the court, seeking the court to overturn that determination by the prosecutor's office. All right, let's talk about the release rights of the defendant. You do have a right to conditions of release to be set by the court. However, I believe, Mr. Torano, the state has filed a motion for detention. Is
I
that
have,
correct?
Judge. Earlier this morning, I filed a motion via e-court seeking detention in this matter. Your Honor should have received that, and notice of motion and certification filed by me, as well as counsel should have received it. I would ask that this matter be set down for a detention hearing next week. I believe that there's a date that we have in mind to determine whether or not Mr. Muldrow will remain detained or if he will be released with conditions.
All right. Counsel, have you received a copy of the state's motion for detention of Mr. Muldrow?
Yes, Your Honor, we received this electronically at 9:05 this morning.
All right, thank you.
You're welcome.
The court will set a hearing as previously discussed with counsel in my chambers. The detention hearing will be held next Wednesday, May 30th, 2018 at 9 o'clock in the morning. Mr. Muldrow, at that detention hearing, the burden is on the state to show that there are no conditions of release that the court could impose on you that would assure your appearance in court, to protect any member of the community, and to make sure that there is no obstruction of justice. Those are the two goals of the criminal justice reform statute. You have a right to testify at that hearing if you wish. If you do testify at that hearing, there are certain limitations on the state's use of your testimony. They cannot use your testimony at a detention hearing in any subsequent proceedings on the issue of guilt. Is that clear? It can be used against you if you testify at a detention hearing and then you testify at trial and that testimony is inconsistent. The testimony can be used against you to impeach your credibility. It can also be used in subsequent hearings if you're released on conditions and you don't show up to court for some reason and the state seeks to revoke any conditions of release. They can use your testimony. Is that clear? You also have a right to call witnesses at that hearing and present evidence to the court by way of proffer or otherwise, meaning documentary evidence or arguments of counsel. Do you understand that as well? I'm sure counsel will discuss your rights at the detention hearing as we move forward. In addition, counsel, I've set a pre-indictment hearing date for June 25th, 2018. That'll be held at 9 o'clock in the morning as well. All right, so Mr. Muldrow will be held in the Morris County Correctional Facility pending a detention hearing currently scheduled for May 30th at 9 o'clock in the morning. Anything else from your perspective, Mr. Troiano?
Judge, just for the record, briefly, I would note for the record that Mr. Muldrow, through the defense counsel, has been provided with discovery for the purposes of the pretrial detention hearing next week. I provided that to him. It's both documents and a disc that contains numerous statements and another video. I believe that he has acknowledged receipt of the discovery, but I would like the record to reflect that as well.
Do you have discovery, counsel?
Yes, I signed a document acknowledging receipt. Not only have I received it, and I appreciate the courtesy of the state in providing it, I've reviewed some of it. Judge, I didn't want to just place on the record, with your permission, the fact that formally the state has asked for an adjournment of the detention hearing. And defense counsel concomitantly does not object to that adjournment request. And by my computation, the Wednesday scheduled detention hearing date would be day 2 of the state's up to 3 days adjournment. Does anybody disagree with my...
When did you file the motion?
This morning.
Doesn't count weekends, holidays don't count, so it would be day 2. And you have a right to ask for additional time if you need it, counsel, as you are well aware.
I am, and we're not going to.
All right, very good. We'll see you both on Wednesday at 9 o'clock in the morning.
Thank you very much, Judge.
Appreciate your courtesy. Thank you, sir.
Thank you, counsel.
You're welcome. Okay, sir.
Counsel, he may be held downstairs for a little while if you need to follow up your conversation with him downstairs.
I appreciate that courtesy, and without putting on the record, I have another
Yes, no, not a problem.
court date.
All
Thank
right.
you.
You'll see.
Thank you, sir.